in the part 3 of the Constitution, Article number 12 and 35. This is the fundamental right. The fundamental right are the enshrined in the part 3 of the Constitution from the Article number 12 to 35. In this regard, the frames of the Constitution track the inspirations of the Constitution of USA. That is the Bill of Rights. The part 3 of the Constitution is the rightly described as the Magna Carta of India. It contains a very long and comprehensive list of the justifiable fundamental right in our the Constitution and more elaborate than those found in the Constitution of any other country. The world, including the USA, the fundamental right are regulated by the Constitution to all the person without any discrimination. The equality of all the individuals without limitation. They afford the equality of all the individuals, the the last public interest and unity. The last public interest and unity. The last public interest and unity of the nation. The last public interest and the unity of the nation. The fundamental right and the meant for the promoting the ideal of the political democracy. The fundamental right are the promoting the political democracy. They begin the establishment of an authoritarian and the despotic rules in the country, and that protects the liberty and freedoms of the people against the invention by the state. The operate as the limitation on the tyranny of the executive and arbitrary law of the legislature. In the short, they aim at the establishment of the government and not the fundamental right and so because they are granted and protected by the Constitution, of the land. They are fundamental also in the sense that they are most essential for the all-round development, the material, intellectual, moral, and the spiritual of the individual. The origin of the Constitution provides for 7 fundamental rights. Right to equality, Article number 14 to 18. Right to freedom, Article number 19 to 22. Right against exploitation, Article 23-24. Right to freedom of religion, Article number 25-28. Cultural and education right, Article number 29-30. Right to property, Article number 31. Right to constitutional independence, Article number 32. This is the how much total fundamental right. This is the 7 fundamental right are provided. This is the first is the right to equality, the Article number 14 to 18. Right to freedom, the Article number 19 to 22. Right against explanation, Article number 23, 34, 24. So Article number 22, 24 is the right against explanation. Right to freedom of religion, यानी कोई भी धर्म आप ले सकते हो. Article number 25, 28. Cultural and education right, Article number 29, 30. Right to property, Article number 31. Right to constitutional Reminders, Article number 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act 1978. It is the made a legal right under the Article number 300A, the Part 12 of the Constitution. So, at the present, there are only 6 fundamental rights. The fundamental features of the fundamental right. The fundamental right that granted by the Constitution are the characterized by the following. The fundamental right granted by the Constitution are the characterized by the following. Some of them are available only to the citizen, while the others are available to all the person, whether citizens, foreigners, or legal person like the corporation or the companies. The fundamental rights that granted by the Constitution are the characterized by the following. Some of them are the available only to the citizen, while others are the available to the person, whether the citizen, foreigner, or legal person like the corporation or companies. यानी कंपनीज लेने के लिए बाहर दूसरा देश का फॉरेनर भी ये फंडामेंटल राइट के अंडर में ये भी दे सकते हैं कोई भी पर्सन्स लीगल पर्सन लाइक कॉरपोरेशन और कंपनीज के लिए दे आर नॉट एब्सोल्यूट बट qualified the state can then impose responsible restriction on them. They are not absolute but the qualified the state can then impose the responsible restriction on them. However, whether such the restriction are the responsible or not is to be the dedicated by the courts. Thus, the stick at the balance between the right of the individual and those of the society as the whole between the individual liberty and social control. All of them are the available against the arbitrary action of the state. However, some of them are also available against the action of the private individual. Some of them are the negative in the character, that is the place limitations on the authority of the state, while other are the positive in nature, conferring the certain privileges on the person. They are justifiable, allow the person to move the courts for the enforcement if and when they are violated. They are the defended and the granted by the Supreme Court. As the aggregate, the persons can directly go to the Supreme Court, not necessarily by way of the appeal against the judgment of the High Court. They are not the sacrosanct or the permanent. The Parliament can the curtail or the repeal them, but only by the Constitutional Amendment. But only by the Constitutional Amendment Act and not by the Ordinary Act. Moreover, this can be done within the affecting the basic structure of the Constitution. The amenability of the fundamental right is explained in detail in the chapter 11. They can be suspended during the operation of the national emergency, except the right to granted by the Article number 20 and 21. Right they granted by the Article number 21 and 22. Whether the sixth right granted by the Article number 19 can be the suspend only when the emergency is declared on the ground of war or the external aggression, that is the external emergency, and not on the ground of the armed revolution, that is the internal emergency. The suspension of the fundamental right during a national emergency is the explained in the detail in chapter number 16. The scope of the operation is limited by the Article 31A, the saving of the law providings for the acquisition of the state extra. Article number 31B, the validation of the certain act and the regulation included in the nine schedules, and the Article number 31C, saving of the law, the giving effect to the certain the directed principles. Their application to the members of the armed forces, the paramilitary forces, police forces, intelligence agencies, and the elongated service can be restricted on the abrogated by the Parliament Article 33. Their application can be restricted to the martial law. Their application can be restricted for the material law in the force in any area. Martial law, that means the military rule that imposed under the vulnerable the circumstances to the restore order, the Article number 34. It is different from the imposition of the national emergency. Most of them are directly enforceable self the executive, while a few of them can be enforced on the basis of the law made for the given the effect to them. This is the law can be made only by the parliament and not by the state legislature to so that the uniformity throughout the country is the maintained. Article number 35. The definition of the state. What is definition of the state? The term of the state has been the use or in the definition of the provision the concerning the fundamental right, as the article number 12 has that define the term for the purpose of the part 3. According to it, the state that include the following: the government and the parliament of India, that is the executive and legislative organ of the union government. The definition of the state. The term of the state has been used in the different the prevention the concerning the fundamental right. As the article number 12 has the defines the term for the purpose of the part 3. According to it, the state include the following: the government and parliament of India, that is the executive and legislative organs of the union government. The government and legislative of the state, that is the executive and legislative organs of the state government. Number C is the all the local authorities. All the local authorities, that is the municipalities and the panchayatis and the district board and the improvement trust extra. All other the authorities, that is the statutory or the non-statutory authorities like the LIC, ONSC, shall extra. Thus, the state has been defined in the sessions to so as to in the include all it is the agencies. Thus, the state has been defined in the WIDA, the sense so as to the include all it is the agencies. It is the action of these the agencies that can be the challenges in the court as the violating the fundamental right. According to the Supreme Court, even at a private body or the agency working as the instrument of the state falls within the meanings of the state under the article number 12. Law as law inconsistent with the fundamental right. The article number 13 that declared that all the law that are the inconsistent with or in the declaration of any of the fundamental right shall be developed. In other words, it is the expensively provided for the doctrine of the judicial review. This the power has been the conferred on the Supreme Court Article number 32 and the right to court Article number 226 that can be then declared as a law unconstitutional and the invalid on the ground of the contribution of the any of the fundamental right. The terms law in the Article number 30 has been the given either with the connotation so as to the include the following: the permanent law the enacted by the parliament or the state legislature, temporary law like the ordinance issued by the presidents or the state governor, the statutory instrument in the nature of the delegate legislative executive, the legislation like the order, bylaw, rule, regulation, or the notification, and non-legislative source of law, that is the custom or the uses having the force of law. Thus, not only the legislative but any of the above can be the silence in the court as the violating the fundamental right and hence can be the declared as the violation. The Articles number 30 declared that the constitutional amendment is not a law and hence cannot be the silences. However, the Supreme Court held in the Keshavananda Bharatiya case 1973 that is the constitutional amendment can be silenced on the ground that it the violate the fundamental right form the part of the basic structure on the constitution and hence can be declared as the word. The fundamental right at the glance the right to equality article number 14 to 18 the consists of this is the right to equality article number 14 to 18 the equality before law and the equal protection of law article number 14 the equality before law and the equal protection of law article number 14. B number is the prevention of the discrimination on the ground of religion, race, caste, sex or place of the birth article number 15. The prohibition of the discrimination on the ground of religion, race, caste, sex or the place of the birth article number 15. The equality of the opportunity in the matter of the public employment article number 16. The equality of opportunity in the matter of the public employment article number 60. The abolition of the untouchability and the prohibition of it is the practice. The abolition of the untouchability and the prohibition of it is the practice article number 17. This is the article number 17 and is the abolition of the titles except the military and the academic article number 18. This is the right to equality. Right to equality, the equality before the law and equal protection of law. Equality before law and equal protection of law, article number 14. The prohibition of the discrimination of ground of religion, race, caste, sex, or the place of birth, article number 15. The equality of the opportunity in the matter of the public employment, article number 16. The abolition of the untouchability and the prohibition of it is the practice. This is the article number 17. The abolition of the title except the military and the academic article number 18. यानी कोई भी टाइटल ले सकते हैं. Right to freedom article number 19 and 22. This is the right to freedom article number 19 and 22. The protection of the sixth right regarding the freedom of speech and expansion, यानी कोई भी स्पीच दे सकते हो, स्पीच एंड एक्सपेंशन. दिस इज द आर्टिकल नंबर 19. असेंबली, एसोसिएट, मूवमेंट, रेसिडेंट एंड द प्रोफेशन. This is the article number 19. The protection of six rights regarding freedom, speech and expansion. Number 2 is the assembly. Number 3 is the association. Number 4 is the movement. Number 5 is the resident. And number 6 is the profession. Article number 19. Protection is respect of the convention of offense. Article number 20. Protection in the respect of convention for offense. Article number 20. Protection of life and the personal liberty. Protection of life and personal liberty. Article number 21. Right to element education. Right to element education. Article number 21A. Right to element education. Article number 21A. Protection against the arrest and the detention in the certain cases. Article number 22. Protection against arrest and the detention in the certain cases. Article number 22. So right to freedom, this is the right to freedom. Number 1 is the protection of six regarding freedoms, and the number 1 is the speech and expansion. Number 2 is the assembly. Number 3 is the association. Number 4 is the movement. Number 5 is the resident, and number 6 is the profession. This is the article number 19. And article number 20, protection in the respect of the conviction of offense. Article number 21, the protection of life and the personal liberty. And article number 21A, the right to element education. And article number 22, the protection against the arrest, the protection against the arrest and the detention in the certain the cases. Right against exploitation. Article number 23 to 24. Article number 23. The prohibition of the traffic in human being and the forced labor. Prevention of the traffic in human being and the forced labor. Article number 23. यानी लेबर को फोर्स नहीं कर सकती है. Article number 23 under. The prohibition of the employment of the children in the factories extra. Article number 24. यानी चिल्ड्रेन को फैक्ट्री में लेना मना है. This is the prohibition of the employment of children in the factories. The article number 24. Right to freedom of religion. Article number 25, 28. Right to freedom of religion. Article number 25 to 28. Article number 25. The freedom of the conscience and the free profession, the practice and propagations of religion. Freedom of conscience and the free profession, the practice and propagation of religion. Article number 25. Freedom to the manage religions affair. Freedom to manage religion affair. Article number 26. The freedom from the payment of tax for the promotion of any religion. Article number 27. The freedom from the payment of tax for the purposes of any religion. Article number 27. Freedom from the attending religions, the instruction or worship in the certain educational institution. यानी आप कोई भी रिलीजन के लिए एजुकेशन के लिए खुल सकते हो. यानी फ्रीडम फॉर अटेंडिंग रिलीजियंस, द इंस्ट्रक्शन or worship in the certain educational institution. The article number 28. Freedom for the attending religion, the instruction or worship in the certain educational institution. Article number 28. The culture and the educational right. Article number 29 to 30. The protection of language, the script and culture of the minorities. The article number 29. The protection of language, script and culture of minorities. Article number 29. Right of minorities to the established and the administrator. The educational institution, Article number 30. Right of minorities to the established and the administrator. The educational institution, Article number 30. Right to constitutional reminders, Article number 32. Right to constitutional reminders, Article number 32. Right to move the Supreme Court for the enforcement of fundamental right, including the rights. Right to move the Supreme Court for the enforcement of the fundamental right, including the writ of the habeas corpus, mandamus, and the prevention, the certiorari, and the quo warranto, Article number 32. Quo warranto, Article number 32. The Article number 32, right to move the Supreme Court to the enforcement of fundamental right, including the writ, the habeas corpus, and the mandamus, prevention, and the certiorari, and the quo warranto. The fundamental right of foreigners. The fundamental right available only in the citizen and not to foreigners. This is the fundamental right available only the citizen and not to foreigners. This is the prohibition of the discrimination of the ground of religion, race, caste, sex or the place of birth. Article number 15 a foreigner के लिए नहीं है. Equality of the opportunity in the matter of the public employment. Article number 16 ये भी नहीं है. तो protection of the sixth right regarding freedom of the speech and the expression, assembly, association, movement, residence and the profession. Article number 19 ये भी नहीं. तो protection of language, script and culture of minorities. Article number 29 ये भी नहीं. तो right of the minorities to the established and the administrator education institution. Article number 30 ये भी नहीं. तो right to free fundamental right available to the both citizen and the foreigner. तो ये foreigner और Indian citizen के लिए है. This is the number 1. Equality before law and equal protection of law. Article number 14. यानी हमारा इंडियन सिटीजन के लिए भी जो लॉ है प्रोटेक्शन के लिए वो फॉरेनर के लिए भी सेम है. द आर्टिकल नंबर 14 के अंडर ये है. द प्रोटेक्शन इन द रेस्पेक्ट ऑफ द कन्वेंशन फॉर द ऑफेंस, यानी रेस्पेक्ट करना पड़ेगा. तो इंडियन के लिए जितने रेस्पेक्ट फॉरेनर के लिए सेम रेस्पेक्ट. दिस इज द आर्टिकल नंबर 20. द प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी, यानी जीवन जो उसका लाइफ है वो प्रोटेक्शन देना पड़ेगा और लिबर्टी को प्रोटेक्शन देने पड़ेगा. तो आर्टिकल नंबर 21 के अंदर है. तो राइट टू एलिमेंट्री एजुकेशन, एजुकेशन के लिए भी है 21A. द प्रोटेक्शन अगेंस्ट द अरेस्ट एंड द डिटेंशन इन द certain cases. Article number 22. द परमिशन ऑफ द ट्रैफिक इन ह्यूमन बीइंग एंड द फोर्स द लेबर. आर्टिकल यानी लेबर के लिए भी ये फोर्स नहीं कर सकती है. फॉरेनर भी है और इंडियन सिटीजन भी है सेम. तो ये आर्टिकल नंबर 23. द प्रोटेक्शन ऑफ द एम्प्लॉयमेंट ऑफ द चिल्ड्रन इन फैक्ट्री, यानी चिल्ड्रन को फैक्ट्री में लेना माना है. तो ये आर्टिकल नंबर 24 के अंदर है. द फ्रीडम ऑफ conscience and the free profession, the practice and propagation of religion. Article number 25. Freedoms of the conscience and the free profession, the practice and the propagation of religion. यानी रिलीजन के लिए आप प्रोफेशन फ्री प्रोफेशन एंड प्रैक्टिस भी कर सकते हो. तो आर्टिकल नंबर 25 के अंदर है. Freedom of the conscience and free profession, the practice and propagation of religion. Article number 25. Freedom to manage the religion affair. Article number 26. Freedom from the payment of tax for the promotion of any religion. Article number 27. Freedom from the attending religion, the instruction or worship in a certain educational institution. Article number 28. This is the right to equality. The equality before law and equal protection of law. The equality before law and equal protection of law. The article number 14 said that the state shall be not the deny to any person equality before the law or the equal protection of the law within the territory of India. This is the provision that confers right on all the persons, whether citizens or the foreigners. Moreover, the what person include the legal persons via the statutory corporation, the companies, registered societies, or any other types of legal person. The concept of the equality before the law is on the British origin, while the concept of equal protection of law has been taken from the American Constitution. The first concept cannot, the absence of any special privilege in favor of any person. Number B is that the equal subjection of all the person to the ordinary. This is the article number 14. तो ये है इक्वलिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉ. तो ये जो है द कॉन्सेप्ट ऑफ इक्वलिटी बिफोर लॉ इज ऑफ द ब्रिटिश ओरिजिन. ये ब्रिटिश ओरिजिन का है. वेल द कॉन्सेप्ट ऑफ इक्वल द प्रोटेक्शन ऑफ लॉ हैज बीन टेकन फ्रॉम द अमेरिकन कॉन्स्टिट्यूशन. द फर्स्ट कॉन्सेप्ट कैन नॉट the absence of any special prevalence in the favor of any person. Number B, the equal subjection, the absence of any concept, the absence of any special prevalence in the favor of any person. The absence of any special prevalence in favor of any person. The equal subjection of all the person to the ordinary law of the land administered by ordinary law court, and no person, whether rich or poor, high or low, official or the non-official, is the aim of the law. No person, whether the rich or poor, high or low, official or non-official, is the above the law. The second concept. The second concept, of the other hand, cannot. The equality of the treatment under the equal circumstance both in the privilege conferred and the liberties imposed by the law. The similar applicable of the same law to all the persons who are the similarly situated, and the like should be the third. Alike within any the discrimination, thus the former is the negative concept, while the latter is the positive concept. However, both of them and am at the establishing the equality of the legal status, the opportunity, and justice. The Supreme Court held that where the equals and the unequals are the threat that differently, Article number 14 does not apply, while the Article 40 the provide the class uh, resolution it the permit responsible classification of the person object and the transition by the law, but the classification should not be the arbitrary, artificially, or the eventives. Rather, it should be based on and the intelligible Tibetan and the sustainable destination rule of law. The concept of the equality before the law is an element of the concept of the rule of the law, the propounded by the APTK, the British jurist. Is the concept has the following three elements or the expect. Number one, the absence of the arbitrary power, that is, no man can be the punished except for the branch of law. The equality before the law, that is, the equal subjection of all the citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law court. The primacy of the right to the individual. That is the that is the constitution is the individual as the defendant and the enforced by the court of the law rather than the constitution being the source of the individual right. The first and the second elements are the applicable to the Indian system and not the third one. In the Indian system, the constitution is the source of the individual right. The Supreme Court held that the rule of the law and embodied in the Article number 14 is the basis, the features of the Constitution. Hence, it cannot be the destroyed even by the amendment. Exception of exception to equality. Exception to equality. The rules of the equality before law is not the absolute, and there are the constitutional and other the exhibition to it. These are the mentioned below. The presidents of Indian and the governor of the state enjoy the following the immunities. Article number 361. The presidents of India and the governor of state enjoy the following the immunities. The article number 361. The president or the governor is not the answerable to any court for the exercise and the performance of the powers and the duties of his the office. No criminal proceedings shall be the instituted or the continue against the president or the governor in any court during this term of office. No process for the arrest or the imprisonment imprisonment of the president or the governor shall be issued from by from any court during his the term of office. No civil proceedings against the president or the governor shall be initiated during his term of the office in any court in respect of any act done by him in his personal capacity, whether before or after he enacted upon on his office, until the expiration of the 2 months next after notice has been delivered to him. No person shall be liable to any civil to the criminal proceedings in any court in the respect of the unpublication in either newspaper or by the radio or television of the sustainability true report of any procedure, sustainability true report of any positions of either House of Parliament or either House of the Legislature of the State. Article number 361A. No member of the Parliament shall be the liable to any proceeding in any court in the respect of anything. No member of the legislature of the state shall be the liable to any proceeding in any court in the respect of anything said of the vote given by him in the legislature of any committees. Therefore, the article number 194. The article number 31C is and the accepting to the articles 14. It provides that the law made by the state for the implementing the directive principle content the clause or the causes of the article number 39 cannot be the selected on the ground that they are the violatives of the article number 14. The Supreme Court held that whether the article 31C comes in the article number 14 goes out. The foreign sovereigns rule the ambassador and the diplomats enjoy immunities from the criminal and the civil proceeding. The UNO and it is the agencies enjoy the diplomatic immunity. Prevention of the discrimination on certain ground. The article number 15 that provides that the state shall not discrimination against any citizens on the ground only of the religion, race, the caste, sex, or the place of birth. The two crucial word in this the prevention are the discrimination and only. The word discrimination means to make and the adverse discrimination with the regard to or to distinguish the unfavorably from the others. The use of the word only the connotes that the discrimination on other ground in is the not the prohibited. The second permission of the article number 15 say that no citizen shall be the subject to any disability, liberty, the restriction or the condition on ground only of the religion, race, caste, sex, or the place of the birth with the regard to the access to the shop, the public restaurant, hotel, and the place of public entertainment or the use of well, tanks, battings, cart, road, and the place of the public restore and the maintenance well or partly by the state funds that dedicated to the use of the general public. This permission the prohibited the discrimination both the state and the private individual. While the former the prohibition the discrimination only by the state. Therefore the exception. There are the for the exception to this the general rule of the non-discrimination. The state is the permitted to make any the special the permission for the women and the children. For example, reservation of the seat for the women in the local bodies or the permission of free education for the children. The state is the permitted to make any the special permission for the advancement of the any socially and educationally backward classes of the citizens or for the scheduled caste and the scheduled tribes for the expellent mm, scheduled tribes for the example reservation of the seat of the free concession in the public educational institution. The seat is the empowered to make any the special provision for the advancement of any socially and the educationally backward classes of the citizens or or for for the scheduled caste or the scheduled tribes regarding the administration to the educational institution, including the private educational the institution, whether aided or the uh, unaided by the state, except the minority educational institution. The state is the empowered to make any the special provision for the advancement of any economically weaker sections of citizens. The further the state is the allowed to the max the permission for the reservations of up to 10% of seat for such the section in the administration to educational institution, including the private educational institution, whether aided of or the united by the state, except the minority educational institution. This reservation of up to the 10% would be in the addition to the existing reservation. For the purpose, the economical weaker section would be the notified by the by the state for from time to time on the basis of the family income and other indicators of the economic descendants. Reservation for the OBC in the educational institution. Reservation for the OBC in the educational institution. The above the expression was added by the 93rd Amendment Act of 2005. In the order to given the effect to this the provision, the center enacted the center at educational institution, the reservation in the Admission Act 2006, providing at the quarter of 27% for the candidate belonging to the other backward classes OBC in all the central higher education institution, including the Indian Institution of Technology (IITS) and the Indian Institution of the Management (IIMS). In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quarter Act, but the court direct the central government to exclude the creamy, creamy layer creamy layer the advanced section among the OBCs the while the implementing the law. The children of the following the difference the categories of people belong to the creamy layer among the OBCs and thus the will not get the quarter benefit. The person the holding the constitutional post like the president, vice president, judge of Supreme Court and High Courts, the chairman and member, UPSC, SSPSC, CEC, CAG, and so on. The group A the class 1 and group B the class 2 officer of all the Indian central and state the service and the employees the holdings the equivalent posts in PSU, banks, insurance organization and universities, etc. And also in the prevalent the employment, the person who are in the rank of the colonel and above in the army and equivalent posts in the navy and air force and the parliamentary force. Oh. force, the air force, and the paramilitary force. The profession like the doctors, lawyer, engineer, artists, authors, the consultant, and so on. The person in a case in the trade, business, and the industry. The people holding the agriculture land above the certain limit and the vacant land or the wood linked in the urban areas. The person having the gross the annual income of more than 8 lakhs or the possessing wealth above the expansion limit in 1993 with the creamy layer the ceiling was the introduced it was the 1 lakh it was uh, subsequently the revised to the 2.5 lakh in 2004 and 4.5 lakh in 2008, 6 lakh in 2013 and 8 lakh in 2017. The reservation for EWS in the educational institution. The above the exceptions was the added by the 103 by 103 Amendment Act 2019. In the order to given the effort to this the permission, the central government issue an order in 2019 providing 10% reservation to the economical weaker section EWS in the admission to the education institution. The benefit of this reservation can be avoided by the persons belongs to the EWS who are not the convert under any of the existing the schedules of reservations for SCs, STs, and OBCs. The eligibility certain laid down in this regard as follow. The persons who the family has cost the annual income the below to the 8 lakhs are to be the identify identified as EWS for the benefit of the reservation. The income will the include the income from all the source that is the salary, agriculture, business, for pension, etc. And it would be the income for the financial years prior to the years of application. The person who is the whose the family's owned or the possess any one of the following the asset are to be the excluded from the being the identified as EWS. The irrespective of the family income. 3 acres of agricultural land and the above the resident of on the surface above the resident of the national resident of the plot of 200 square yard and the above the areas of the notice of the municipality. The property is held by the families in the difference the location of uh, the different place the cities of the government of the weather of the land and the property is holding test to the determine EWS status. The families for this the purpose would the included the persons who the seek the benefit of reservation his are the parents and the siblings belong to the age of 18 years as also his are the spouse and the children belong to the age of 18 years. The equality of the opportunity in public employment. The equality of opportunity in the public employment. The article number 16, 16. The article number 16 the provide for the equality of the opportunity for all the citizens in the matters of the employment or the appointment uh, appointment to any the office under the state. No citizen can be the discriminate against or be the ineligible for any the employment or the office under the state or on the ground of the only religion, race, caste, sex, descendant, place, or the birth of resident. Therefore, the exception to this the general rule of the equality of the opportunity in the public employment. Parliament can be the prescribe the residence as the condition for the certain employment or the appointment in the state or union territories or the local authority or other authority as the public employment the recruitment as the resident act of 1957 expired to 1974. There is no such the provision for any state except the Andhra Pradesh and Telangana. The state can the provide for the reservation of the appointment or the post in the favors of any backward classes, but that is not the educatory the representatives in the state the service. A law can the provide that the in incumbent of and the office related to the religions or the denomination, the institution or other members of it is the governing body should belong to the particular religions or the denomination. The state is the permitted to make the provision for the reservation of up to 10% of the appointment of the post in the favors of any economical weaker section of the citizens. This reservation of up to 10% would be in the addition to the existing reservation. For this purpose, the economical weaker section would be the notified by the state from time to time on the basis of the family income and other indicators of the economical dependence. Mondol commissions and aftermath. In 1979, the Morarji Desai government they appointed the second backward classes commission under the chairmanship of B.P. Mandal as the member of the parliament in the term of the article number 340 of the constitution to the investigate the condition of the socially and the educationally backward classes and the suggest the uh, measure 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 for the advancement. This commission that submitted it is the report in 1980 and the identify as the many as the 3743 casted as the socially and the educationally backward classes. They constitute nearly 52% the component of the populations, the excluding the scheduled castes and scheduled tribes. The commission recommended for the reservation of 27% government jobs for the others backward classes OBCS show that the total reservation for all SCs and STs OBCs amount to 50%. It was the after then the years in 1990s that the VP Singh government declared the reservation of 27% government job for the OBCs. Again in 1991, the Narasimha Rao government introduced two cents. The prevalence to the report by Purar, the prevalence to the Purar section among the OBC in the 27% quota, that is the adoption of the economical criteria in the granting reservation and reservation of another 10% jobs for the poorer economical backward section of the high casted who are not the covered by any existing schedule of the reservation. In the famous Mandal case 1992, the scope and the extent of the Article 16.4 which the provided for the reservations of the jobs in the favor of the backward classes has been the